saying that this has been very much a core effort, a collective effort by a wonderful group of people that I've had the privilege to work with, and you're going to hear from them today. But I'd just like to say a little bit about them before we start. You've met Jenny Lander here, but you've met her in the context of sending you emails and sorting out your expenses. But actually, she's a distinguished scholar in her own right and a member of the core team. She's a postgraduate fellow at the University of Warwick at the moment. She's recently completed and passed a brilliant PhD. And I hope she doesn't mind me saying that she's getting married in 2 weeks' time. She's been doing all the organising of this workshop instead of organising her wedding. So I owe her an immense gift of gratitude, reward for her caring labour to me and to the research team. So Jenny has been my research assistant for the last year in the UK, as well as doing her PhD and also being a postdoctoral fellow. The second member of the team, where is he, is David Otieno. He's at the back, sitting there at the back. David is a lecturer at Mount Kenya University and also now studying for his PhD at Utrecht University in the Netherlands. He can't get away from me because I'm going to be his joint supervisor for this PhD. But David has been fantastic in helping me do the research in Kenya. Obviously, as an outsider, it would have been absolutely impossible for me to be able to do field work here in Kenya without a huge amount of support locally. So David has been tireless in his support for me as a research assistant over this period. David is a postgraduate from Warwick University, so I called on a favour of a former graduate from Warwick to help me do this. And so he's going to be doing his PhD on a subject matter that's close to the research that we have been conducting over the last year. So a tremendous amount of thanks goes to David for all the effort and all the conversations we've had as we've travelled around Kenya, and all the discussions, and all the filling of bits of paper that I constantly lost and he found, and whatever. So we've spent a lot of time together over the last year, and it's been great. And then finally, the other member of the team, Dr. Agnes Moroka, who's the other research assistant from Kenya. I've known Agnes for a number of years. Agnes is a lecturer at the University of Nairobi in the law faculty, known to many of you. Did a fantastic talk here last week, along with other colleagues, on the F word, on feminism, and it was one of the most successful events that the British Institute has held. And on Twitter, it was the 4th most tweeted, is that the way you say it? Trending there, thank you, in Kenya as a result. So Agnes has a way with words. I know this because Agnes was at Warwick as well. You notice the connections again, my university. She did her master's and then she did her doctorate with us, and I was one of her supervisors for that. So Agnes has been fantastic in keeping me on the straight and narrow, and also providing very insightful ideas and ways of helping on the research. And so she and David have argued lots of things about their understandings, and today they're giving a joint paper together. So the outcome of that is a joint paper. So huge thanks. And I would also say she's given birth to a baby during this time. Her third son was born during the period. So, and I'm used to this because she gave birth to her first son, when she was studying at Warwick, and I think she was pregnant with her second son when she was doing her PhD Viva, and I was terrified she'd give birth under the strain. And I was saying, you've got to go and see the midwife in the morning before you do this. I'm not going to be responsible for this baby being born early, etc., etc. So she's able to cope, like many African women, with multitasking, shall we say. So thank you much to Agnes as well. So that's many others have helped, but that's the core team. So after that, let's start. I think Celestine's going to keep us the time. I hope. She's got her pieces of paper.
Tools for the job?
Yeah, tools for the job.
So when I show you this...
Yeah, and then just shuts me up. Yeah.
And then when I finally just say...
Yeah, then I'll sit down. So, shall I start? Yeah. Okay, so I've just put up there all these logos on the right-hand side, and these are the people I need to thank, really. The University of Warwick has many institutions, but each of these elements of Warwick University gave us the money to enable us to be able to undertake this workshop. So I am responsible at Warwick for this thing called the Global Research Priority on International Development, which means it brings together work on international development throughout the University of Warwick under one umbrella, which is this thing called the Global Research Priority on International Development. And also, I'm a member of the law school, so I have to, and the other institutions, the law school provided us some money, and also the Institute of Advanced Legal Studies. So I just wanted to say that I owe them thanks for that. Okay, quickly then. Yesterday, we saw the policy context for ageing in Africa, and also gendered ageing in Africa, I think. And I'm calling this the top-down day, in a way. So we looked at the way international policy was created and developed. So the policy context was provided by participants yesterday, and just a very brief idea, I think, of some of the ideas that came out. You might disagree. Older citizens are now being recognised as having legal rights, but they're yet to be realised, but at least there's a debate about that. The importance of the African family. It's clear that there's a policy decision to promote and strengthen its role in the care of older members. It's the primary means at the moment by which older people are cared for. But then there's this question of resilience. How capable is the African family in being able to provide the care? And we've seen it's like in many other parts of the world, families aren't really resilient enough to be able to deal with the issues around ageing. So as we get older, not everybody, but we need more. And that's why we have a need for social welfare, including, as we discussed yesterday, informal social security and social protection to bolster. But that it is bolstering the family. It's not replacing family care. And I think that came out of the discussion yesterday. For me, and I think for a theme of yesterday, is the gender issues. Older women are the largest constituency of older people. 56-58% of older people in Kenya, 65 plus, are women. And they're disproportionately affected by negative changes, as I would say, that have gone on. They take care and support for the terminally ill and for children orphaned through the AIDS pandemic, and other issues of change and urban migration have disproportionately affected women. So they go into old age, not everybody, but many, as most disadvantaged, subjected, as we saw yesterday, to abuse with little ability to sustain themselves due to lack of property rights on widowhood or divorce or other life events. Now, that isn't to suggest there isn't a vulnerability of older men without family support. So it's not suggesting that that doesn't need recognition as well. So we need also to think about the interaction, and I know this is close to
Prafula's heart, really. What's the effect on women of caring responsibilities within the family? We looked at that yesterday as well. Is the labour of caring, when you're doing the job of caring, is that activity recognised? Is the future caring for a larger cohort of much older people recognised? Who is going to do this? Can we rely on those traditional roles and, to do that? The daughter-in-law, the daughter, the son providing help, and so on. Who is going to do the work in the long term? In what context? With what access to additional resources? So I think those issues were percolating around. And that brings us to, the other issue that we talked about yesterday, the Sustainable Development Goals. Just to remind you what it is, this is Sustainable Goal 5.4, the target: recognise and value unpaid care, domestic work through the provision of public services, infrastructure and social protection policies, and the promotion of shared responsibility within the household and the family as nationally appropriate. So recognising things are going to be different in different countries, but seeing the need for states to recognise and value unpaid care, not leave it all to the family and to particular members of the family. And this is the goal under the Sustainable Development Goals. An academic who's been very involved in this reduces it, came up with this idea of, as I mentioned yesterday, recognise care, reduce it wherever possible by, if you've got a washing machine, you don't have to wash clothes. If you've got a vacuum cleaner, you don't have to use a broom, etc. So how do you reduce? By providing better water facilities and so on, reduce the costs and the labour of care and redistribute it between family members so it doesn't fall particularly on one or another. So it's a public-private idea that's in the Sustainable Development Goals. So, just to summarise then, it seems to me the provision of care, this is also came out of yesterday, the provision of care generally has not attracted the policymakers' attention yet. Caring as a concept, as what we do, it's coming through, but it's not there yet. So there's limited use of the concept of care to inform policy making on ageing. It's changing. We're beginning to think about it. We saw that from the contributors yesterday and from the international framework. But we haven't thought through, in many societies, the long-term care that we need to think about. How do we start from early age to think about what's going to happen to us in old age, so we don't go into old age, as Prafula said to me this morning, pushing a big stone up a hill. As we get older, because it is a big stone. So using a life course approach, thinking about each stage in life as to what impact that's going to have on us when we get older, and is it different for men and women. So that's what I learned from yesterday. But what today is about is, in a way, a bottom-up idea. So that also was the theme that came from yesterday. We had speakers that said, hang on, customary law is not necessarily what is in the books that Coltrane wrote restatements in the 1950s, 60s. We need to know what's going on the ground. We need a contextual approach. What is actually going on in ageing in Kenya or any society? And to think about that. We saw from Ambrina on the Skype yesterday, also it's quite interesting to think in different ways about the same issue. Thinking about sex working and prostitution as a care arrangement. Well, what I've tried to do in my research is to rethink woman-to-woman marriages, and I've put that in quotes because that isn't the language that is used within the communities that practice this arrangement, but it's what it's known colloquially in the courts. Think about this institution, which has been about providing children, particularly sons, for women who have not been able to produce sons for their lineage. But can we think of this as a different sort of arrangement? And does it have other aspects to it as well as the producing of sons? Because what we find is, and I'm assuming that we all know what woman-to-woman marriages is, and what it involves. Is this knowledge everybody understands? It's a process by which bride wealth is paid, and I've got chiefs in the room who've described this to me, and now I'm describing it back to you, so I might get it wrong. But it's a process by which an older woman who is unable or has no living sons or not had sons enters into an arrangement whereby a younger woman comes into the arrangement in exchange for the bride wealth to her family to provide children for the older woman's lineage. So it's an arrangement to primarily, historically, to deal with the problem of the lack of sons. But is it something else? It seems to me, when I started to think about it, it always involves an older woman and a younger woman. That's the nature of the arrangement. So it's always the case, and it tends to be, the research shows, it's often women in their 60s who enter into these arrangements, late 50s, 60s. So they're already quite well down the life course. And then they're getting a young woman, often much younger themselves, who comes into the household. So what impact does that have? I started to think, interesting, this is an older woman getting access to a type of labour through marriage that normally is associated with men. They're getting wives, although I'm uneasy with that idea. So what we thought we would do is we would test out to see what was happening, whether women-to-women marriages were actually a means by which some older women who are able to pay bride wealth were able to have access to care, which is often associated with marriage. We looked at 6 communities, and there we are. And the reason why I asked whether you'd all got this background note that I produced, there's more detail on this in the paper, so I can not have to refer to so much, because Celestine is going to cut me off in a minute. So this is, we went to 6 communities and undertook interviews and focus groups with those sets of people, with the women themselves involved in the arrangement, with elders and chiefs who are here. And I made a promise that when we did it, we would invite them back to hear what we'd learnt. And so that's trying to keep that promise here today. And also with other stakeholders, particularly legal profession and advocacy groups who have been involved in adjudication and dispute resolution in relation to woman-to-woman marriages. So it seems to me the advantage of doing this was it enabled me, and I hope others, to see caregiving and care receiving more clearly, because it's being done in an unusual way. It sort of exposes it, rather like we saw yesterday with Ambrina. So it exposes the way in which care is valued and recognised, because it's not the norm, it's not a husband and wife relationship, it's a woman and woman, a younger woman and an older woman. And it takes place in a rural socio-economic context where kinship care is the norm, it seems to me, with little available social protection for those people that are involved. Access to the 2,000 social protection shillings for some, but for very few. And it offers a glimpse of a life course approach for both women. Now, what do I mean by that? I should just quickly say we've decided in the research, or I decided, not to adopt the naming arrangements that are often associated with this practice, which is husband for the woman, the older woman that engages in the process, who initiates the process, and wife for the younger woman. What we've used the terminology is older woman, and younger woman, because it allows us to see the care arrangement. And we also found, when we started to do the work, we were getting two groups of younger women. Older younger women who had once been a young woman in the arrangement, who was now aging and herself was now widowed. So she, in the wifely role, she is now older. And also young women who had recently, or more recently, entered into the arrangements. So, what do we find? The practice is still very much in existence. We had no difficulty finding many people that wanted to come and talk to us about the arrangement. The primary reason stays the same: to provide boys, to maintain lineage, and to secure social status. Fine. But there's clear evidence, I think, from the research, and I have to say I've only done the first level of looking through all the interviews, and we haven't by any means analysed it all yet, so this is straight from the sort of thoughts. There's clear evidence in the interviews and what people said to us that it was seen as a way of caring for older women, and this came through very clearly from both the interviews with the elders and women themselves. So people would say it is to provide sons and it's to look after an older woman. To look after the older woman. It's to do because she's older. Which women are the beneficiaries of this care that's provided to them? Those that are able to pay bride wealth, who can either through their husband, who might still be alive, and the arrangement is between the husband and wife to enter into this idea, and the husband provides the bride wealth, but it's the woman that pays it. So it's transferred, or it might be herself if she has those resources, depending. What are the advantages for older women? She has someone to take on her normal wifely responsibilities, including working on the family farm while she contributes to resource provision. So she takes responsibility. The older woman takes responsibility for providing for the family, and she provides well, many of the interviews said. The women work together happily in most cases, work together on the farm, in the family plot, and so on, and in the house. It gains children, particularly sons, to provide protection, social protection, and status for the older woman. And when she is no longer able to work, when she's very elderly, it is someone with a recognised role to care for her. Not stranger care. This is a wife, in a sense. She's known her younger woman partner for many years. So it's a process by which the care is provided for a woman in what you might normally expect a wife to be providing to a husband. Advantages for the younger woman. Now, I know we're on controversial territory here in a way, but the advantage, I'm looking at what we found. Advantages for the younger one depends very much on her life stage. So she gains in the early stage recognition of her position. She's a wife, she's either often described as a daughter-in-law, a daughter-in-law of a son that has not existed, or the relationship, because of the age difference, she's described as a daughter-in-law. But she's recognised because the customary practices have been carried out. Often she'll have children already, which means that her position is rather vulnerable. She secures her own and her children's future. The children she already has out of wedlock, if you want to put it in that way, and the children she has within the arrangement. And she gets access to what we described yesterday as bequeathable wealth. She is entitled to the inheritance that comes with the customary arrangement. She shares work. It's uneven. She's told what to do by the older woman, often, but they share. And every single person we interviewed volunteered why they like these arrangements. No domestic violence. They work together and they don't experience violence. So that is what was liked about the arrangements by the parties. when do things get less advantageous for the younger woman? There are tensions when the older woman is very elderly and is no way more able to provide. She's not able to go out and do that manly role, and she needs more care. Now, I've got to think more about what we've heard from the interviews there. So there's less, the older, younger women were less happy than the younger women. So it's a lack of resources, is it? It's the same for anybody who's looking after an elderly person and unable to care. So it might be about poverty and resources rather than the arrangement. Many problems on widowhood. But we find, didn't we yesterday, that there are problems for all women who are widowed. The question is, are there more problems for women who are widowed from this arrangement than they would be for others? Now, the arrangement is clearly supported by the chiefs and the elders. They try to enforce the arrangements when they're challenged, and they recognise and support the arrangement. Differences within communities to the amount of dispossession that goes on, which is obviously related to, I think, pressure on land in the different communities. Finally, I'm nearly there, I'll stop in a minute. Advantages for the wider family. Daughters and other family members are relieved of the responsibility of looking after their elderly relative because they're able to rely on, in a sense, somebody that is a wife, but is also doing domestic, is a carer. So the younger woman, in the eyes of the rest of the family, possibly is also a care worker, but within the marriage framework, not within the employment relationship. So this isn't somebody that's rewarded through wages, they're rewarded through access to property. Implications. Provide this particular institution, it seems to me, from what we can see, looking at it through new eyes, provides care for older women, which relieves pressure on other family members. The younger woman is in a better position with the legal framework of marriage than within the legal framework of employment, where she would receive far less social and legal protection. It acts in part as a life course strategy for both the older woman and for the younger woman. It secures them in older age. Now, what I'm not saying that it's an arrangement to be promoted. I'm not saying that. I'm looking at what's going on. I don't, that's not, in a sense, what I'm talking about here. It doesn't address any of the gendered inequalities within marriage. It reproduces them because it's all about producing sons to start with. It doesn't tackle presumptions about caring roles because they're still divided. The younger woman does not necessarily freely choose this arrangement. And we had very different opinions on this as to, whether they felt they were choosing to go into this or whether they didn't feel they had much choice. It was their life circumstances that meant they had to do it. And they're not necessarily choosing the male progenitor, although that is clearly changing very much. So the younger women do choose the men that they have relationships with. It's not chosen for them. What I am saying, and this is the last slide, is it's important to study what's happening on the ground in specific contexts. So this is just an example of thinking about the way one arrangement possibly provides care for older women in a rural area. And it's an example of an everyday practice. And we need to do the bottom up as well as the top down. It helps us to understand more broadly, by disrupting our understandings, how care is provided, how it's recognised, if at all, and how rewarded. So it's to inform top-down policy making and to suggest perhaps we need to do more types of research which finds out what's going on that informs a socio-legal understanding of traditional arrangements. Thank you.
Thank you, Anne. You kept to the time.
Did I?
Stand up and go like that.
Oh God, I was not looking at you deliberately, so as to... Yeah.
Okay, so now we'll hear from the other two members of the team, Dr. Moroka and
Should I get out of the way?
and you have 20 minutes between the two of you.
So good morning. So one unfortunate thing with this presentation is that it has been done by two people who almost always never agree. But at least on this occasion we agreed. So it's probably the first time we are agreeing this year. Now, Anne has given a background of woman-to-woman marriages, and I'll probably pick from that point before, engaging in the question of how dispute is resolved. And when we looked at this arrangement, when it started off, we thought, this is kind of one homogeneous kind of practice. But when we got to the communities, we began to realize that the practice manifests differently across different communities. So even the reference, the way the two parties in the arrangement refer to each other changes as we move from one community to another. So for instance, when we went to the Nandi, we found there were women-to-women marriages just like in other communities, but we also found instances where mothers were essentially in some form of woman-to-woman marriage with their daughters. So a mother would be having daughters, all daughters, and telling one of them that for you, don't get married, so you will stay behind. And she will have sons, and the sons will inherit the land. And so the relationship is similar to other woman-to-woman marriages. But now the difference is that in this particular case, it is an arrangement between a mother and a daughter, which was unique to the Nandi because we didn't encounter it in other places. Now, we also encountered the more regular one where a woman would marry for herself. So she would be like, I don't have children, or I don't have sons, and I want to perpetuate my lineage, and I want care, and I want respect in the community, so I'll get another woman. So this was also another category. It was probably the most prevalent because we found it in all the communities that we went to. Now, a third category that we found basically common among the Kamba was where someone would marry for a dead son. So you had like 5 daughters and 1 son, and the son dies. And then you marry another daughter, rather you marry another woman, ostensibly for this son. So this lady who is married is referred to as the wife of the son who died. So she actually takes the name of the wife of the son who died. Now, the reference is that Kambas have this word called Mwaitu. So they would call her, so the younger woman would call her Mwaitu. And this other one would call, the older one would call her like daughter-in-law. Now the concept of Mwaitu is even more complicated, and it was outside the context. Now this happens a lot when you try to do ethnographic studies, because a lot of local languages do not have an English equivalent. So what we got from Mwaitu is not necessarily a mother, like a mother figure kind of. So it needs kind of a linguistic study to establish exactly what that Mwaitu would mean. But it was kind of a mother in general terms. Now, the other category that we found out was kind of woman-to-woman marriages where the woman would marry for a son who never existed. So the woman would presume that she had a son and bring another woman, and the woman who is brought in would be presumed to be married to a son who never existed. So the woman would take up the name of a family name in the clan. Or in some certain instances, we encountered a name where a man actually donated his name in quotes to the younger woman. So the arrangement among the Kamba, the most common one, is this one of daughter-in-law and mother-in-law arrangement. Now, among the Kipsigis, we found polygamous woman-to-woman unions, where an older woman would actually marry 2 younger women. But there was a caveat to that in all these instances, there was a question of, which man would have children with this woman. Now, whereas the older woman was allowed to have 2, 3, 4, 5 women, so essentially she would be in a polygamous union, the man would not be the same man for all these women. So each woman would have her own independent man. But so the men could not be polygamous, but the older woman was allowed to be polygamous. Now, when we went among the Luo, we ran into an obstacle because we went to Migori County, and Migori County and parts of Homa Bay are basically inhabited are mostly inhabited by Luo Abasuba. So we went and talked to the chiefs in Suna in Migori, and they told us, how this practice manifests among the Luo, which is not any different from how it manifests in the other communities. But when we went to the Luo elders told us that, the Luo of other regions in Nyanza don't have this practice on the basis that, the Luo Abasuba were originally Bantus. So the Abasuba migrated from Uganda and into Kenya, in the pre-colonial period. And so they carried their Bantu, so they carried some Bantu cultural practices. So then the woman-to-woman marriage among the Abasuba, because the Abasuba were eventually assimilated and became Luos, but seems like some of their practices remained. And so, according to the elders, they were saying that this practice is born out of their identity as emerging from the Abasuba, their Abasuba lineage, rather than from them being Luos. But you see, the Abasuba also, the same region, the Abasuba border, the Kisi on this side who practice this, and also the Kuri at this side who practice this. So the challenge we ran into here, and this may need a secondary study or a historical study or an anthropological one, is to examine whether this practice may have been borrowed from the Kisi and the Kuria, or whether the Abasuba actually had it before, or whether it was there among the Luo, and probably the elders are telling us something different, and that probably it has changed in other parts, but has not changed in Gwasi area and Migori area where we visited. Now, the way in which disputes were resolved in this kind of unions largely depended on the nature of the disputes. Now, so for instance, in polygamous woman-to-woman unions, we realize that immediately a conflict emerges, and we'll look at some of the main issues, main forms of conflict in these marriages in a short while. So we notice that in polygamous woman-to-woman unions, the first person to resolve the dispute, so the first person to resolve dispute.
I'm assuming you're splitting the division.
Yes, you are.
Yeah.
Which case though?
Okay, yeah. So the first person to resolve the dispute would be the older woman, and if she fails, the dispute would go to her husband, because a lot of times the older woman who marries the younger woman, a lot of times she also has a husband. So she is a wife to her husband and a husband to the younger woman. So when a dispute comes, then the first person to resolve the dispute would be the older woman, and then the husband will intervene, and a lot of times the dispute will move from that point to the elders, to the community elders, and eventually to the assistant chief and to the chief, and so on. Now, there was a general resentment against formal justice systems, because the women felt, much as global women movements and NGOs a lot of times usually say, women don't go to court because they don't have money and the courts are far and they're illiterate. Now, our findings here were that these women actually don't even see the courts as forms of justice at all. So the question of distance and money it rose in one or two cases, but largely a lot of them saw their disputes as being customary private disputes. And their claims before the chiefs and before the elders were actually customary claims. So they see courts as being, state instruments that are removed from customary structures. And they see their disputes as located within customary structures. So within this context, they are generally averse to court systems. So we were in Migori town, which is, very close to Migori High Court. But we only found one case that had been reported to court. But even this case had been reported to court after several interventions. So there were several interventions by other options, by other people, before, a court was considered. So the court is actually the alternative dispute resolution in this particular context, because people are trying other systems and considering the court as an alternative. Now, some of the causes of conflict as I wind up, well, the first one is that the woman, when she's brought in, the argument is that she's coming to care. One of the arguments is that she's coming to care for the older one. Now, if she fails to care, then this usually brings about a problem. Now, the second one is that because she's brought in to bring forth sons, and because you can never predict whether you will have sons or not, if the event that she has daughters also, this usually brings conflict between her and the older woman and the clan. Now, another cause of conflict was that they were found to be, the cases of extramarital affairs. Now, extramarital affairs in these marriages were different from extramarital affairs in heterosexual marriages. Because in heterosexual marriages, when you are cheating on your wife or your husband, you are sleeping with somebody else. Now, in this case, when the younger woman comes, the older woman chooses a man for her. Sleeping with another man other than the one who was chosen is considered an extramarital affair. Or sleeping with other men, several different men. Like today you have one, because in some circumstances the older woman does not choose, so she's told, choose a man. Now once you've chosen, you have to retain that one. So if you have several of them or different types of men over a particular period, and that is considered an extramarital affair. So the manifestation of extramarital affairs is very different. And so these matters would a lot of times go to the chief, because the legal system understands extramarital affairs very differently. So it is the chiefs who are able to, understand the community dynamics behind all these processes. So in summary, as I conclude, the claims put forth by women in these arrangements are not legal claims. They are customary claims. And so because they are customary claims, it is the customs that provide a protection system for them. And if we remove custom out of this, a lot of people say these are not marriages. So the chief has to actually assert the customary claim, not the legal claim in terms of what the law says. Because case law and the doctrine of precedence, the doctrine of precedence is based on the assumption that cases that are similar have to be determined in a similar way. Now, you realize, you call it stare decisis, right? Now, you realize here that these marriages are very, very unique. So the doctrine of precedence that is applicable in state legal systems cannot apply here at all, because almost each case is unique in its particular sense. So I'll stop there and invite Agnes.
Thank you.
Good morning. So basically, the findings, I just want to do this very quickly because Celestine is soon going to be lifting the time banners. But what David found during the field work and basically thinking through the way in which women in woman-to-woman marriages access justice then got us thinking about what is marriage first and foremost, and thinking about it in our context after the Constitution, our current Constitution, and the Marriage Act 2014, Matrimonial Property Act 2014. Now, the Constitution at Article 45 provides that everybody has the right to marry a person of their choice of the opposite sex. The two of them have to be consenting and so on. All right? And just early this year, I believe it was in April, we saw the rules. There was the gazettement of the rules as to registration of marriages, and in particular registration of customary law marriages. This coming after the provision in the Marriage Act of 2014 that provides all marriages in Kenya must now be registered. Now, this is an interesting provision because when we look at the rules of the 2017 rules as to registration of customary marriages, I don't see a leeway as to allowing the registrar of marriages to register a union between a woman and a woman. Therefore, without this element of registration, are woman-to-woman marriages recognized within the law as it currently is? Obviously, the judiciary has passed decisions saying that the woman-to-woman marriages are marriages and they are recognized. But again, even within these laws, when we look at the case law, there are challenges. For instance, you will find there are judges who will insist that the rights have to be followed. If there was a goat that should have been slaughtered, it ought to have been slaughtered. If there were things, payment of whatever that should have been done, that must have been done for us to say that this marriage exists within customary law. And then there are judges who say, well, not necessarily. Because sometimes the challenge with woman-to-woman marriages is that these rights are not followed from A to B as it is. I mean, it will be different, as David says, from one scenario to the next. And sometimes, for instance, I don't know some of you if you saw there was a very interesting documentary on K24 about the woman-to-woman marriages, where even the younger woman says, I don't know whether I was married as a wife or whether I was a daughter-in-law. I was not quite sure. Meaning that the rights which were followed can sometimes vary. Now, when that situation comes to court, do we then write it off and say there is no marriage? The judges who disagree and who say no, what was the intention of the parties? What did they intend to do? And we can get that by getting testimony from people who were involved. So the challenge with the woman-to-woman marriages, therefore, is already we are coming from a situation where they were recognized through case law and the decisions of the judges, but it was not clear in the instances whether it is the intention of the parties or whether there was some mechanism that was followed and rights were performed. But now we are in this situation, the Constitution and the Marriage Act, saying, number one, you can only marry a person of the opposite sex, and number two, that this marriage ought to be registered. So how will these women then be accessing justice? Are we then locking out certain women from accessing justice with regard to marriage, disputes in marriage? And then also bear in mind that the cases that have come to the formal courts have to do with succession and inheritance. Well, what about other disputes? Because from the fieldwork we found that there were disputes that did not relate to succession or inheritance, where parties wanted to separate. There were issues to do with caring for children, child custody, and so on. So how are these issues going to be addressed? They don't come through the formal courts. And therefore, we then asked ourselves, is the formal law the best way in which the woman-to-woman marriages, disputes in woman-to-woman marriages can be addressed, or are there other mechanisms? And coming from the women themselves, they preferred the customary dispute resolution mechanisms. And also from the law, we are seeing that they're being locked out. So for me, from a feminist perspective, it got me thinking about this tendency that we have in Kenya to think that formality is the best way, that formality equals protection of rights. And also thinking about this introduction of registration of all marriages, including customary law marriages, as a positive thing. Yes, we are saying that there is greater recognition of the customary law marriages as it is because the statutes recognize and now it is written down. But is that necessarily a good thing? If you look at, for instance, what has happened with land, and now I'm drawing comparisons, seeing as, land and property issues are very close to my heart. We've had situations where people have been left landless as a result of registration of land in Kenya. We've had situations where land grabs and irregular land acquisitions and so on have become rampant, and we can actually blame registration systems for this problem that we are now seeing. Are we going to be seeing the same thing moving forward with regard to marriages? Are we learning that in a pluralist system, we necessarily need to recognize the existence of other forms of law and other systems of doing things besides, common law and so on, and the formal law mechanisms, but without necessarily then insisting on bringing elements of formal law into the customary law systems? Can we allow these customary law systems to exist without necessarily having to, sort of alter them? Are there ways? Because we can actually get justice, I believe, for women in women-to-women marriages through the customary law systems. We don't necessarily, the women themselves are not going to court. And it's not an issue to do with costs or anything, but many of them feel that we are better understood within the customary law system. So this then is an indictment on the women's movement, which has really championed the cause for registration. And I wish my good friends, Professor Kamau and Justice Baraza were here, because they have been instrumental in sort of informing the discourses to the greater protection of rights. And obviously one thing we will see is that there were many amendments to the Marriage Act, prior to it being then passed with, this requirement for registration, there were many things that were removed from there. And then we just ended up with the issue of registration, and without such issues as, say, consent, you have to ask if it is a polygamous union, if it is under customary law. There was the issue of getting the consent of the first wife, getting parties to agree. All these issues were then deleted, and we just ended up with the issue of registration. But I believe we have a challenge in how we are protecting women in women-to-woman marriages, and that is, as Anne said, it's not trying to promote these unions, but trying to say that they already existed, and they existed in a particular way. Can they be respected? And also they serve a particular purpose. They provide care and all sorts of things. Surrogacy is one of them, traditional surrogacy mechanism. So can we find a way of protecting them rather than altering them? Thank you.
So we have one more presentation. Next, because we're going to Catherine.